Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about motions hearings. But before we get to that, don't forget to click like on this video if you're enjoying it, and if you're enjoying all these videos, don't forget to click subscribe with a little bell to be notified of future videos. So, motions hearings. What this is fighting legal issues. When we have a case, factual issues are determined by the jury and legal issues are determined by the court. A motion is a request for a judge to make a ruling on a legal issue. So in a criminal case, what we are usually doing is a suppression hearing or some other motion to determine the admissibility of evidence. In other words, we're trying to either keep illegal evidence out or to determine exactly what the evidence is that the state's going to be presenting to the jury. When does this happen? It generally happens after setting a case for trial. So in other words, when we try to do motions issues before we set the case for trial, most judges aren't going to want to hear those. Sometimes we can file the motion, they can hold it in what's called abeyance. They just sit on it until we decide whether or not there's going to be a plea offer or some other disposition that's going to be accepted or rejected. If we set the case for trial in Colorado, criminal cases, we almost always set a motions hearing and a trial date. So in other words, what we're doing is we're fighting legal issues, things that we need the judge to make a ruling on before the trial. So if the defendant has made a statement, we're probably going to be challenging that. If there was a warrant issued, arrest warrant, where evidence was gained from the arrest warrant, we have the ability to look at it to determine whether or not we think it was an illegal warrant or a warrant that was issued when it shouldn't have been. Same thing with search warrants. We challenge the facial sufficiency of the warrant based on the affidavit and what the judge granted, along with what they collected on the warrant. So we're fighting these legal issues, and the judge has to make a ruling on it. Now, as I said, sometimes we do these motions before we've even gotten an offer in a case where there's just something glaringly wrong. I can remember a DUI I did a few years ago where a person was charged with DUI. Never should have been the probable cause statement granting probable cause never should have been granted, since what my client did was not a DUI by the statute. And I can get into that in another video if anybody wants to ask why, tell that short story. But that is the question and answer for today. If you would like your own question answered in a future video, you can always put it in the comments below, tag me on Twitter, or email it to me. And as always, you have a right to remain silent if a police officer asks you questions about what you've done, what you have, where you've been, what you know, or anything. You always have a right to say that you don't want to talk to them, and if they persist, that you want an attorney.